Perhaps the lawyers of the ponentes did not realize that, or they were not familiar with the rules of Congress. As I said, this is a world of difference. Now, this is a transcendental case. Ang laking constitutional issue. Wala man lang oral arguments, or at the very least, a consultation with some members of Congress or members of the bar na nakakaintindi ng rules ng Congress regarding the procedure. In that matter alone, Mr. President, kasabihan ninyo mga lawyer, falsus omnibus, falsus unos, falsus omnibus. Mistake in one, mistake in all. In that manner, they wouldn't have decided based on their unfamiliarity with the legislative process. May mali agad eh. Pati ba legislative rules natin gusto nilang palitan? Ganun ba yun? Maybe not everyone may appreciate the importance of the legislative calendar of Congress. But us, it is a big deal. That's why I'm stressing this point. Concurrent joint resolution pa nga when we approve this calendar, only to be misinterpreted and used erroneously in this case. Nag-adjourn daw yung 19th Congress. Kaya na-archive lahat. Now, may kinopya lang, kopya, mali pa. Sabi nga kanina ng ating distinguished gentleman from Tarlac, hilaw. Hilaw yung complaint. Hilaw din yung decision. In addition to this factual error, Mr. President, it can be seen in the website of the House of Representatives that the 3 impeachment complaints were referred to the Committee on Rules and were consigned to the archives on February 6, not February 5, as claimed in page 78 of the decision. Nag-housekeeping lang ang House, kaya in-archive, hindi to end the Congress. This archiving were not the results of the ending of the 19th Congress, but because of the fact that the 4th complaint were already filed and transmitted to the Senate. Eh dito pa lang, Mr. President, pilit na patunayan na barred ang 4th complaint. Kapag ayaw, may dahilan. Kapag gusto, may paraan. Now, to continue, Mr. President, and this is very much related. The Supreme Court, by the way, if it is wrong, if the complaint done by the House of Representatives was wrong, we cannot correct a wrong with another wrong. The Supreme Court essentially amended the Constitution by removing the 3rd mode of filing of impeachment complaint. This 3rd and speedy mode was enshrined there for a reason. In times that there is an urgent need to impeach a person who is influential and powerful and may use his position to evade the law, the 3rd mode, which is the fastest way, was provided in the Constitution. Why don't you ask the authors of this provision in the Constitution? Constitutionalists or CONCON delegates Munsud, Ascuna, Sarmiento. So, Mr. President, continuing, if the Supreme Court is now changing the meaning of initiating, then at the very least, please apply it prospectively. However, they are applying this new ruling retroactively, which is a violation of the doctrine of operative facts. Kung ganito kanilang kagustuhan, at susundin natin basta-basta, apektado din dito yung nakaraang impeachment, the impeachment proceedings. In the words of retired Supreme Court Senior Justice Antonio Carpio, I quote, "The said Supreme Court decision practically voided the impeachment proceedings against former President Joseph Estrada and former Chief Justice Renato Corona." Pag gusto talaga, may paraan. Pag ayaw, may dahilan. Pero wag naman sana pati sa mga ganitong bagay that will ultimately affect future impeachment and legislative rules and proceedings.